The Texas Family Code provides a very stable framework within which any dispute can be resolved. With regard to conservatorship, or also known as custody, the legislatures provided a framework within which those decisions can be made, and the central feature of this framework is the public policy that is expressed in Section 153.001 of the Code. And it says, the public policy of this state is to assure that children will have frequent and continuing contact with parents who've shown the ability to act in the best interest of the child. I want you to note that this was written with the focus on the child, not the parent. The legislature could have easily stated this as assuring that parents would have frequent and continuing contact, but they chose instead to put the focus on the child, because that's what it's all about. It is also the public policy of this state to provide a safe, stable, and nonviolent environment for the child, and to encourage parents to share in the rights and duties of raising their child after the parents have separated or dissolved their marriage. An equally central directive is found in Section 153.002, which tells us about the best interest of the child. The best interest of the child shall always be the primary consideration of the court in determining the issues of conservatorship and possession of and access to the child. Possession of and access to the child in the vernacular is going to be visitation. This law requires that the unique facts of each case be reviewed through the lens of the child's best interest, not what each parent wants, and not any preconceived notions one might have about these matters. A third and equally important tenet is found in Section 153.003, which tells us that the court shall consider the qualifications of the parties without regard to their marital status or to the sex of the party or the child when determining which party to appoint as a sole managing conservator, whether to appoint parents as joint managing conservators, and whatever the terms and conditions of conservatorship and possession will be with the child. So male or female, married or single, the courts must look at each individual's qualifications, regardless of their marital status or their gender. We must also never entertain the notion, which has been disproved by research, which would dictate that fathers can raise only boys, not girls. Any one of us in this room can point to times when we've known a father who raised great daughters or mothers who raised wonderful sons as a single parent. Since the 1980s, the laser has been focused on the child's best interest, and we've seen barriers to custody removed for fathers. The focus on the child's best interest, without regard to is on the child's best interest, without regard, again, to the gender of the parent or the gender of the child. And to further the public policy of encouraging parents to share in the rights and duties of raising their child after their relationship is over, the legislature created a presumption in favor of appointing parents as joint managing conservators rather than appointing one parent as a sole managing conservator. Here we have 153.131b. There is a presumption in the law that the appointment of the parents of a child as joint managing conservators is in the best interest of the child. A finding of family violence removes that presumption. We'll talk about that in a moment. So what exactly does joint managing conservatorship mean? And again, the Family Code comes to the rescue. It tells us very clearly that joint managing conservatorship is the sharing of rights and duties of a parent by both parties, even if the exclusive right to make certain decisions is awarded to one parent. So when joint managing conservators are appointed, then subject to the agreement of the parties, the court is going to specify those rights and duties of a parent that are to be exercised by each parent independently, those rights that will be exercised by joint agreement of the parties, and those rights that may be exercised exclusively by one parent. And what rights are we talking about? Rights of parents such as the right to determine the primary residence of the child, where the child's going to live, the right to receive child support, the right to consent to the child's marriage as a minor, the right to represent the child in legal proceedings, and always important, the right to make educational decisions for the child. One of the first things we have to recognize is that no matter what custodial arrangements are made, both parents retain certain rights, some of which they have at all times, and some whenever they're in possession of the child. Here again, the Family Code specifies these rights. 153.073 of the Family Code tells us that unless a court limits these, a parent who is appointed as a conservator, a joint conservator or a sole or a possessory conservator, will always have the right, and I'm not going to go through all of these, but I do want to hit two or three that are very important. One is to receive information from any other conservator of the child concerning the health, education, and welfare of the child. That's a right. You don't have to ask permission. You have a right to have the other parent communicate with you about how the child is doing. You have a right to confer with the other parent to the extent possible before a decision is made concerning the health, education, and welfare of the child. You have a right to access to medical, dental, psychological, and educational records of the child. A frequent complaint we hear from parents as they come in is that they can't get things from the school. This law ensures them that right. They can take that order and they can go to that school. They can get that information. They can consult, a parent can consult with a physician, dentist, or psychologist of the child. You don't have to wait to be invited to go to the doctor. You can contact the doctor and get information. You can consult with school officials about how the child's doing at school. You can attend school activities, and most importantly, you can be designated on school records as being a person to be notified in case of emergency. Another complaint that we hear of often when a parent has enrolled a child in school, they didn't put the other parent's name. You have a right under Texas law to have your name on those school records as a contact. Now, there's the list, and you have them in your materials. These are the rights of parents at all times. Now let's talk about rights and duties that a parent has during periods of possession. So when a parent has a child, they have, of course, the duty of care, control, protection, reasonable discipline of the child, the duty to support the child, including providing clothing, food, shelter, the right to consent for the child to medical and dental care that doesn't involve an invasive procedure, and the right to direct the moral and religious training of the child. So sometimes parents don't share the same faith, but when you have the child in your possession, you can take the child to your place of worship. So it's within this framework that important decisions on conservatorship and possession can be made by parties to the suits and also by the courts when the parents are unable to agree. And within that framework that I've described, trial courts are called upon to make decisions that flesh out the public policies and these directives one case at a time, one family at a time. Custody and possession decisions are the most important critical decisions for parents and courts. And for the courts, these decisions are going to be made based upon the facts, the evidence, the law, and the law, both statutory, the Family Code, and case law that has interpreted the Family Code. The statutory framework provides the bones, if you will, and as the legislature cannot possibly legislate every conceivable thing that can happen to a family in a case, it's up to the judge to put flesh on those bones using the most important tool that the judge has available, and that is judicial discretion. Judicial discretion is the judge's exercise of judgment to choose between alternatives based upon fairness, weighing the facts unique to the case at hand. It's fundamental to the judicial system. Its exercise is an integral part of the role of a judge, and it is required in order for our jurisprudence to function properly. Judicial discretion entitles or enables application of the law to the subtle nuances of the case. It's informed by training and experience, and it's tempered by wisdom. It's impossible to write specific laws to address all these situations when laws can apply and then sometimes conflict. Judges hear the evidence firsthand. They are best positioned to properly weigh the relevance, the admissibility, and the credibility of the evidence. Judges have to have wide discretion to do this, and I assure you there is nothing cookie cutter about families. Although judges have broad discretion in the resolution of family law cases, they are not gods, they're not omniscient, and they make mistakes from time to time. With discretion comes accountability. The exercise of judicial discretion can be reviewed by an appellate court under an abuse of discretion standard. And the test for abuse of discretion requires an appellate court to determine whether the trial court acted in an arbitrary or unreasonable manner without any reference to guiding rules or principles, without any reference to the law. In exercising judicial discretion and to resolve questions of custody or possession, judges look at a host of factors. This is a non-exhaustive list. I could have slide after slide of factors for courts to consider, but I do want to hit some of the ones that we usually see. Each parent's willingness to work with the other parent after the case is over, the fitness of each parent, the child's relationship with each parent, the expressed preferences of children who are 12 years of age and older, the ability to stabilize a child's school life, the proximity of each parent's home, the employment of the parents, including how flexible they are to handle family emergencies if they have to be called away from work to go pick the child up at school or stay home with the child if the child is ill, and then the age and number of the children. For any one factor to apply, there has to be admissible evidence to support it. The trial court will weigh these factors and determine an outcome that must be grounded always in serving the child's best interest. On many occasions, judges, like myself, have had two very equal, loving, engaged, and communicative parents before us. Judges don't have to worry about these parents. They will likely enter into an agreement for the resolution of the custody and possession issues. And you know why? Because they can talk. They can talk about the children without anger. They can reach shared decisions, and they place the child's interest before their own. These are the successes that you all will never hear about. They don't come back to court. Parents, but not the courts, have the right and the ability under current law to choose an outcome that would not award either parent the exclusive right to designate the primary residence. And if they do that, then the law requires that they agree upon a geographic restriction within which the child's primary residence must be maintained by them. Parents can choose a geographic restriction as small as a fixed street address to as large as a school district, a city, a region, a state, a country, even a hemisphere. The choices are unlimited, and they depend on the case and the parties. Now, I've seen many cases in which the parents on their own, or through the process of mediation where they settle the case outside of court, agree to share physical possession of the child on an equal basis, where each parent has the child 50% of the time. These same agreements usually call for a geographic restriction on the child's primary residence to be no larger than the county where the child lives and maybe the counties that are contiguous to that county. Out in my area, that can be a big area in West Texas. Unfortunately, a lot of these parents end up back in court, and sooner rather than later, alleging that the agreement for 50-50 possession has become unworkable or inappropriate. And why? Because real life happened. One parent wants to move away from the area that was established for the child's primary residence because that parent has decided to move a long distance away, maybe to get a job there, or they've remarried and their new spouse has taken a job outside of the county where the child is living. Alternatively, we have children who, of course, mature and they want to participate in sports and summer camps and not necessarily spend all their living moments with their parents. In my humble opinion, a blanket presumption in favor of absolutely equal possession can't coexist in a world where parents are mobile, where children grow up and want more time on their own with their friends and their interests, and of course, when the occasional curveball in the game of life happens, and they do. Not all parents are created equal. Some simply fail or refuse to communicate effectively. They fail or refuse to share decisions, and not all of them have similar parenting skills. Or some are just not able to move beyond the emotional pain and the hostility that came with the end of their relationship. Custody and possession should never be about the number of days that a parent has possession of a child. It should always be about serving the child's best interests, informed by the law, the evidence, and the unique facts of the case. There simply is no one parenting plan that is going to fit all situations. Texas already acknowledges through its public policy that a shared plan where each parent has quality time with the child is in the child's best interest. When parties can't agree on these matters, judges have to use judicial discretion within this established framework that we've gone over to determine a parenting plan that is in the best interest of the child. And the Family Code gives our courts the guidance and the tools to make those decisions. But judges must, and we will, make those decisions based on the evidence that is presented and without bias toward mothers and fathers.